Roundtable on alternate dispute resolution in IP, strengthening enforcement, mediation, and arbitration. It is our extreme honor and privilege to host the delegation from the World Intellectual Property Organization and the Office of Controller General of Patents, Design and Trademark. May I please call upon Professor Dr. Ruhi Paul to deliver the welcome address.
Good evening, one and all. So I was given the task to set the tone for the roundtable, and because we have some participants from abroad, so just tell us briefly as to what is the landscape of arbitration and mediation in India, and then we will down to arbitration and mediation of IP disputes. So as we all know, disputes are inevitable, but what is important is how we resolve them. And all over the world, the trend is towards arbitration, various commercial disputes because of the various reasons that it brings efficiency, speed, confidentiality, cost. They are cost efficient if we look at cost from a very holistic perspective. Otherwise, they are quite expensive also. And also, a very important thing is the international recognition of arbitral agreements, mediated agreements, and arbitrated awards and mediated settlement agreements. So these are some of the reasons why the trend is towards exploring alternatives to litigation for resolving commercial disputes. If we look at 2021 Queen Mary University report on arbitration friendliness of any country, then there are three requisites for that. First and the most important is the infrastructure in the legal system which supports arbitration, judiciary with supportive role, and most importantly, the international recognition of arbitral awards and arbitration agreements. So India being the signatory of the Unsettled Model Law as well as New York Convention, so we follow the concept of international validity of arbitration agreement and arbitral awards. You must be aware that we have an Arbitration and Conciliation Act of 1996, and the government has been very proactive along with the judiciary to keep updating the law governing arbitration to keep it in sync with the international developments. And that is why there have been a number of amendments which have been introduced into the Arbitration Act in the year 2015, then in 2019, and most recently there has been an Arbitration Amendment Bill of 2024, which is still at the stage of deliberations. And through these various acts, the government, the major emphasis of the government along with the academia is to provide for institutional arbitration, reduce the intervention of the court to make India to be in sync with the Article 5 of the Unsettled Model Law, which talks about judicial minimalism, and provide for strengthening of the arbitral tribunal. So in 2015, one very important amendment was introduced in Arbitration Act, which provided that the awards or the orders of the arbitral tribunal granting interim measures of protection will be at par with the orders of a civil court. So this is something which was very innovative and was not even provided in the Unsettled Model Law, Article 17. So and then in 2015, government also understood that the bottlenecks were when the reference was done by the court for arbitration, either under Section 8 or under Section 11 at the time of appointment of arbitrators. So in 2015 only, it was realized that the role of the court should be restricted to just look at the prima facie validity of the arbitration agreement in case of Section 8 and under Section 11, just to see the existence of an arbitration agreement. So these are some things which brings us into the sync with the trend which is there in France, which is considered to be a very arbitration-friendly country. Apart from that, there was a tight lining of the times in which arbitrations were to be conducted, and there was this restriction was there in respect of the parties approaching the courts for seeking interim measures of protection. So that was also a concern. So it was decided if the arbitral tribunal is already existing, then the parties should approach the tribunal only for the purpose of getting interim measures of protection. So these were all done in 2015. Later on, again, there was an amendment in 2019 which provided for further institutionalization of arbitration practice by constituting an Arbitral Council of India. So the function of the Arbitral Council of India was to streamline institutional arbitration, recognize arbitral institutions, set down rules and procedures, model rules and procedures to be followed by various arbitral institutions. Now, by promoting institutional arbitration, the role of the Arbitration Council of India was to restrict again the intervention of the court at various stages of the arbitration proceeding. So these were some of the though there were a number of amendments which were introduced, but this was considered to be the most important amendment in 2019. Again, there is a bill which is at the stage of bill only in 24, which has strengthened, again, provided provisions for strengthening institutional arbitration, defined what will be an arbitral institution, and also streamlined the role of the Arbitral Council of India. It also provided for a new concept of arbitration appellate tribunal. This is also a concept which is already existing in some of the international arbitral institutions. So it is again to restrict the intervention of the court at the stage of annulment of arbitral awards. Another important thing which is introduced by this bill is the concept of emergency arbitrators. So this concept is internationally well recognized, but now the bill also provides for emergency arbitrator, which means that even prior to the establishment of the arbitral tribunal, now the parties are not supposed to go to the court and they can simply go to arbitral institution, which anyways already were providing the facility of emergency arbitration. So the only difference which has taken place is now it is being well recognized by the law also in India. When it comes to courts, the courts have also supported the growth of the arbitration law to make it in sync with the international practices. Like in the case of Cox and King versus SAP India, Supreme Court has clarified the applicability of the concept of the group of the company doctrines in the Indian context, which was a concept internationally which was recognized and which also has done away with the concept of the issue of signatories and non-signatories, and how to make the non-signatories liable in case of certain issues. Another important contribution of the Supreme Court's constitutional bench is to restrict the scope of the courts at the stage of Section 11, where they just have to be confined to looking at the existence of the arbitration agreement and not go into the issue of whether the arbitration agreement is stamped or not, because the court decided that this is a matter which the tribunal can obviously look into by applying the principle of separability, which is, so by this judgment of the Supreme Court, they have given importance to the competence doctrine, which is an internationally recognized doctrine. So these are some of the good judgments which the Supreme Court has delivered. Our high courts, Delhi High Court and also Mumbai High Court has been passing very proactive arbitration-friendly judgments. Apart from that, there have been certain other developments which have taken place. PCA has established a regional office in Delhi, which is Permanent Court of Arbitration. We have been able to establish an arbitration bar in India last year, which was a long pending dream of arbitration practitioners. Of lately, we are seeing the appointment of not just the retired judges of various courts as arbitrators, but appointment of arbitration practitioners from the bar, and most importantly, to ensure gender inclusivity, appointment of women practitioners as arbitrators. So this is also something which Indian government as well as the practitioners are taking and while appointing arbitrators. And with the boost to the institutional arbitration, I'm sure that India is going to become a hub of arbitration in few years to come now. Then if we come to the scenario of mediation, so in 2023, we have passed a Mediation Act on the lines of the UN Convention on International Mediated Settlement Agreement. So this is a very important law because this is the law which has now given validity to mediated settlement agreement, which was something which was lacking earlier. India was offering mediation services prior to the act also by various courts in India and by various mediation institutions. But the problem was there were no roadmap, there was no institutionalization of mediation which was taking place. But after this Mediation Act of 2023, It provides for pre-litigation mediation in commercial disputes. It streamlines the process of mediation. It provides for enforcement of mediated settlement agreement. It provides for online mediation. And it also provides for establishment of Mediation Council of India, which will again has the responsibility of regulating the mediation process, recognizing the mediation institutions for offering training program. Now, if we come to the IP scenario and the applicability of arbitration and mediation in India, then in India we have a peculiar setup in which the disputes regarding IP are not arbitrable per se, but there is a distinction which is maintained in India. The disputes relating to rights in rem, such as those questioning the validity, ownership, or registration of IP rights, they are not considered to be arbitrable in India, whereas all the other disputes relating to contractual rights, like issues of licensing, royalty, marketing disputes, etc., they can be arbitrated upon. But when it comes to mediation, now we have a mediation act, we have mediation centers. So not just the Mediation Act, but also the Commercial Courts Act also provide for mediation of commercial disputes, and IP disputes are considered to be commercial disputes. The courts have also understood the importance of the interim relief which is required in IP disputes, and that is why most of the high courts as well as the Supreme Court has been passing judgments where they recognize and trying to balance the importance of mediation of these disputes as well as how important is the requirement of interim reliefs in IP dispute is. So, and there is the Supreme Court cases, there are a number of high court cases also on these aspects. So I think this is broadly the landscape of arbitration and mediation in India. And I thank you all for a patient hearing. Thank you.
Thank you so much. Everyone may realize that Professor Rui Paul is not only the registrar of the university and the administrative head, but is also an expert in arbitration. She has been teaching arbitration and is a scholar on arbitration here. We'll quickly move on to the special address by Mr. Marco Elman. But before that, we thought we would do some felicitations, that we have for the roundtable. Quickly, if may can provide, ma'am, can you please felicitate Mr. Ilman and others as a token of our appreciation for the delegation visit. David? I think we can quickly move on to, unless there is someone who is leaving, we can quickly move on to the panel discussion and we can do the remaining felicitations later, because at the end of the panel we'll have some time. Mr. Ilman has to leave very shortly, and I'm going to ask him to deliver the speech.
Thank you. Many thanks. Particularly thanks to Dr. Rui for the very kind introduction to the subject and showing the trends in India, where I can see clearly an interest to become a friendly jurisdiction on ADR in general, and also on intellectual property matters. What you describe of issues of IP that are not considered arbitrable or mediable in some jurisdiction, indeed, that's a common approach in many jurisdictions where issues related to the validity of IP rights are certainly not considered, while indeed issues like those related to the consideration related to infraction of not of IP rights and the amount of compensation in case of an infraction are considered without problem something that can be brought to a tribunal or to a panel of mediators. The same apply to licensing agreement and all the different type of contract. What we see in WIPO in the Arbitration and Mediation Center is the following. And let me say a few words on that, and then we can go into the details. The reason for why arbitration and mediation are so solicited at the international level are the same that you already explained. One is cost. Second is time. Cost is very simple, particularly for SMEs. We know that enforcement of IP right is becoming, I would say, a barrier to IP right defense in many cases. There are jurisdictions in which defending IP right is almost impossible, even for big corporations. But for a small, it's just no way to enforce those rights in front of court because of the costs. It is not the case in all jurisdictions. There's still a number of jurisdictions where enforcing IP right is not that costly. So we should not copy arguments from other jurisdictions to justify trends in other. I mean, it is clear that in US, a case in front of a tribunal in a case of a patent can be some million of dollars. That's not the case in many other jurisdictions where that's not an argument we can use translate to other jurisdictions. But the reality is there are important resources involved in bringing a case to a court. And because of that, ADR plays a very key role, not only for big corporations, but very particular for SMEs and individuals. When I started working in this sector that I am leading, the IP and innovation ecosystem sector 4 years ago, I clearly identified a potential there. When we started 4 years ago, 16% of our users were individual SMEs. And with some actions, in order to be able to help SMEs to use ADR, we are now reaching the 50% of users being both individuals and SMEs. So indeed, more and more SMEs are using ADR through the WIPO Arbitration and Mediation Center to enforce or to solve disputes on intellectual property. So cost, without doubt, is an issue. Time is an issue. There are a number of areas of IP where what you need is a decision that is taken as fast as possible. One of those examples are the cases related to licensing agreements. Having a dispute between the owner of the right and the licensee made impossible the relationship. So that's a relationship that certainly is very difficult to work. Now, there are different types of different. There may be a small difference in the way of a given amount of royalties calculated, so probably the parties can live with that until a decision is taken by a judge. But there are many other decisions that are quite complicated in terms of territories, in terms of price, in terms of quality, where decision needs to be taken as quick as possible. In all those cases, without doubt, ADR plays a very key role for two reasons. One, the parties can continue doing business, and second, they expect that the decision be taken in months and not in years. And this all, you probably have to consider that globalization and digitalization has played a very key role in making that businesses today takes place more globally. So doing business within the boundaries of a given country is almost the exception today. So many of the companies doing business do business in different countries, in different jurisdictions. And the digitalization makes that the presence of those products and the presence of those companies in many occasions take place in the online context and not in the physical context. These two elements add first complexity to the cases, but make more possible the conflicts arising in different parts of the world. And this creates something that for right holders is very difficult to handle, that is the risk of contradictory decisions between jurisdictions. So it is perfectly fine that something that in a given jurisdiction will be decided in one manner will be decided in exactly the opposite manner in another jurisdiction. And this has a cost for the parties involved that is quite difficult to handle. When you have either an arbitration case or a mediation case, you have the chance of getting a solution that can be global and that have no price in the solution of the case. So in many of the cases submitted to us are cases in which cross-border litigation is something that parties would like to avoid. And that is a good reason why people are going more and more to both arbitration and mediation. And you mentioned one more, that is confidentiality, and that's extremely key on IP. This is something that for those that are not involved in mediation and arbitration sounds a little bit strange, because if there is something always in court, is that we have this sentiment of the way court manage confidentiality. But what we are talking here is something different. It's not the confidentiality of the case, it's the confidentiality of the information submitted to solve the dispute, and that's something different. So in the case of mediation and arbitration, the party can agree in very severe mechanisms of confidentiality that are not able to be agreed in court. Even in court, we know in many occasions court make publicly available the decisions, and that those decisions in occasions contain a lot of confidential information that the parties would not like to be known to the public. So arbitration and mediation give you the whole room and the whole space to deal with confidentiality in a more precise manner. So let me use to conclude that all what you have seen here is what we see in WIPO as the reason why the center is growing and the regime is growing. What I would like probably to add in your own consideration at the national level is the following. We see specific areas in which ADR plays a very key role, the traditional one, domain names, for example. Without the domain name, and particularly the URDP system in place, trademark owner would be in a very difficult position in enforcing trademark rights against byte use in the online environment. So this was created in 1999 with an expectation that was not that high compared to the reality on how it is working today. I mentioned that only WIPO received more than 6,000 cases in 2024. Without that very simple system, that is mainly a contractual system, all those will be cases brought to the judicial system. And those are cases very simple to be solved by a panelist in weeks because of the mechanism that have been identified as the way to solve that problem. Now, technology brings additional challenges, and we know that on top of the system of domain names that we know, there is a tendency to create what are called alternative domain systems, domain name systems, those that may escape from the URDP policy. And if that happens, then a new solution needs to be brought to the table in order to figure out how we solve those cases. We are working on that, and it is possible that some of those that register alternative domain names adopt the URDP policy as a mechanism to solve conflict. If that's the case, the solution will be as simple as it is for domain names. So this is an area that I would like to highlight, and is how technology is creating new opportunities for ADR, and at the same time, those areas require close attention, otherwise they will escape from mechanisms that are already in place and that have proven to be very effective. Second is copyright protectable content is getting more and more online, and more disputes arise in that particular field. In the case of WIPO, the area of faster growth in number of cases is copyrighted material in the online environment. And this is the area of the fastest growth in total disputes. So good to take a look and see at the national level how to handle those cases that are not necessarily industrial property, but mainly copyright issues. Third, as you mentioned, since areas related to validity and registration can is not always the case, but can escape from ADR, a number of cases related to licensing, and in particular, complex IT solutions and software development, that is a key element in the case of India, are the third more regular case of ADR in what we see in the center. So it may be that at the national level, both IT in general, IT conflicts in general, and in particular software development contracts may be an area that requires attention because maybe an area of particular growth at the national level. And finally, we have developed services that are for specific areas of interest. Let me mention two that in my view are key for the country. One is life science. In life science, when the pandemic, the COVID pandemic in 2019 started, one of the big pressure around the world was about transfer of technology. We know that indeed transfer of technology happened in many cases. The Serum Institute in India got a license from AstraZeneca for the production of the vaccine. Many local technologies were able to come to life. You produce a vaccine in India that was alternative to many of the other vaccines. So there was indeed happening a lot of transfer of technology, and some local technology were able to solve the problems. But there was the perception that IP was not facilitating the transfer of technology. And there was the perception that this required somehow pressure for this to happen. And our view in WIPO was that it would only happen if it's voluntarily. But in order for a voluntary transfer of technology to happen, it required facilitation. So we built, using the expert determination rules that already exist, the possibility of consultations in the area of life science for transfer of technology. So one of the parties, let's say the technology seeker, requests that an expert be appointed for the purpose of facilitation of the compensation, contact the technology owner in order to facilitate a possible contract of tech transfer. And this at the beginning sounds like science fiction, but we have cases already in which this has worked very well. So we developed a number of clauses on ADR in life science, and we see two phenomena. At the international level, more and more licensing agreements contain the clauses we developed in WIPO, including some clauses in India. So those clauses will contain ADR already. It may contain the clause in the sense that the case will go to WIPO center, but it may contain that it goes to a national ADR center. But that's an area of particular growth that is life science, and where a concrete service has been developed. There is a guide, there is a lot of material developed by us on life science that may be relevant to you. And the second is standard essential patents. In the case of standard essential patent, in a country that is IT based, that is UK, is a country that is moving more and more in the area of standard essential patent, and is the case of all Asian countries, is the case of South Korea, the case of China, and is the case of Japan in the region, I would say. And I'm sure it will be the case more and more of India. Standard essential patent conflicts call for ADR alternative because the consequence of not use of the technology that is the subject of the standard is a cost that is too high for society. So as you know very well, all those FRAN clauses that exist are related to mechanisms of alternative dispute resolution. In WIPO, we are working with a number of IP offices worldwide, We signed an agreement with the USPTO on standard essential patent. We signed an agreement with the Canadian patent office, and we are in conversation with at least 10 other patent offices in the area of standard essential patent. I'm sure that this is an area that, for a country like India that has a very intensive IT sector, and which is moving into a more high-tech industry projects, a standard essential patent is an area that deserves some attention. So that's from my side, few considerations as a reaction to your very kind presentation.
Thank you.
Thank you, Mr. Ailman. It's a wonderful presentation with a diverse set of views on what's happening at the WIPO and other places. We will now begin with the substantive aspects of what we thought we could also discuss from the Indian side, specifically focused on intellectual property and alternative disputes resolution. With us, we have Dr. Nidhi Gupta from National Law University, Delhi. She is a professor who teaches in arbitration and other areas at NLU Delhi. We have Ms. Abhilasha Nautiyal here, Mr. Aditya Gupta, both are partners at ERA Law. We have Mr. C.A. Brijesh, partner at Remfrey and Sagar. We have Udita Michelle Patro, partner at Anand. We have Mr. Adarsh Ramanujan, who is an independent counsel and with significant expertise in life science industry. We have Mr. Ashutosh Kumar, who has joined us online. He's not in India currently, and he is going to speak on FRAND arbitration and SAPC is going to give that perspective. And Mr. Manu Sanan, who has expertise in investor-state dispute settlement and arbitration. So we have focused on four particular issues. One is the general ADR ecosystem challenges and the issue of arbitrability and what's happening latest with the Supreme Court and with the High Courts and what are the nuances of it. Then we have one major issue that we are litigating currently in India on pre-litigation mediation because of a particular clause which makes it mandatory for mediation, and then we have also a situation where we have to seek interim remedies in certain cases of involving intellectual property. How does that go together? And of course, FRAND and SEP arbitration, and finally with investor-state dispute settlement and arbitration. So we'll begin with Professor Nidhi Gupta on what she thinks are the general challenges on the ADR ecosystem and what's happening latest. Thank you.
Thank you. Thanks, Yogesh. First of all, I think he wants to.
You have to leave? Okay, it's totally fine that you'll have to leave. We know that you have an appointment and then join some other time. The link for this will be available on our NLU Delhi live platform, and then we will send it to you, and then you can enjoy the rest of the discussions maybe, and you can also join on your way in the car. I think we can get it sent if we can get the link sent to.
And
you sent to them?
It's a pity that I will miss, and I really was looking forward for the conversation. But indeed, the agenda continue with another meeting at 5, but it will take probably more than 45 minutes to get there. So I will miss that part, and I was very much looking forward to learn from you. But I do hope there will be. This is a good justification for me to be back in Delhi at certain point. And I do hope I will be more available, and we will plan better, having more time allocated for that conversation.
Definitely. We look forward to your visit again, and thank you so much.
Thank you.
Thank you.
Thank you.
You have shared them the link to the live link.
The one which was.
Sure. Just check whether the link is.
We'll do our best to watch online.
Nishta, I think you can show them the. Okay, so I think we can continue with our discussions. I'll move on to the other side. I think we can move a little closer so that whoever has joined us online. Yeah, no problem. This is yours, right? I think I'll leave that. Just to make it even between the practitioners and the academics. Okay, thank you so much for joining in, and I think tone has already been set, and we'll start with Professor Nidhi Gupta. Ma'am.
Thank you. Thanks, Rajesh. First of all, thanks for giving this opportunity. It's really pleasure to see Aditya and Adarsh, both who are like NLUG alumni. And
Me too,
yeah,
me too,
yeah.
yeah.
And Abhilasha also.
Okay.
So it's NLU Jodhpur heavy.
So NLUG. I used to work at NLUG.
And both of us from NLU Jodhpur.
Yeah, even you, right? Yeah. So, anyways, now when it comes to the ecosystem in terms of legislative framework and all, Professor Ruhipal has already introduced. Like, we definitely have a robust legislative framework, no doubt about it. And we have also worked towards establishing institutions in terms of like 2019 Amendment Act and India International Arbitration Center. But yeah, the Arbitration Council is still not been notified, so that's not in place. So though we have envisaged that there would be an Arbitration Council, but we are not feeling strong enough to notify it, or we are not very clear about how is it going to go. And my understanding says that one of the important reasons with the Arbitration Council is like what would be the relationship between the courts and the Arbitration Council of India? Because establishment of ACI envisages, and if you also go by this 2019 Amendment Act, that 11.6a, which is meant for appointment of arbitrators, that will have to go. So that remains questionable as to if we take away 11.6a, if we bring into ACI, what will be the role of courts? Will they be post offices? And we go back to that SBP, that whether it is a judicial function or administrative function. So that remains, I think, one of the major points of discussion, that whether we are going to actually have that Arbitration Council of India or not. Second important thing, like I'll keep it very short so that then, of course, we also have Mediation Act 2023, but Mediation Act is not for internationally mediated settlement agreements. So that's also, it's for the moment only for the domestic agreements. So although the ADR is needed really very much, as it has been said, it's very much needed in the cross-border disputes, because there the divergence between the jurisdictions seem to be very high. But I think we would be, as a developing country and all, more skeptical in bringing in ADR settlements and getting them enforced in India. I think that will remain, because we see that large number of IP disputes are inter se, but when it becomes cross-border, the public interest, the public policy, national interest, national economic interest, and all that comes in. So that's another one major area or one major challenge that would need to be negotiated or settled, that if we are going for mediation, are we going also for international mediated settlements and the cross-border disputes? So it all looks, in my view, I'm very skeptical of all these things. Like, being an academic, I am allowed to be skeptical also. So, but
They are the ones earning money.
so it looks like it looks very good for optics that we have now Mediation Act, but we are not a party to Singapore Convention. And I don't see that happening in any future. So this is also like another very, very important thing that I just wanted to flag and highlight. And also, when it comes to last skeptical point, has nothing to do with law. When we say whether judges should be arbitrators or not, of course, ACI and all the discussions and envisages that we should have other technical people also, or not, who are not judges, as mediators and arbitrators. But that also seems problematic, because when you don't have an award or a mediated settlement arising from a judge, its enforcement in practice becomes a problem. When it is arbitration, there are also due process concerns, because many a times it has been observed that the technical experts, maybe they are not so proper with the due process when it comes to the whole proceedings, and we all are talking about this due process paranoia and stuff. So that, I think, also becomes important point, that do we see that happening in India, in common law countries, which are so used to adversarial system, that we move away from judges to be arbitrators or mediators? And if that be the case, then what do we do with the technical expertise? How do we bring in technical expertise? So I think these very quick points.
Thank you, Dr. Nidhi. I think this perfectly sets the tone for our discussions on the question of arbitrability of IP disputes. But before that, if anybody has anything to add on, Abhilasha, would you like to add something to this challenge question, ecosystem?
Sure, happy to. I think as a practitioner, the way we see ADR for IP, there are, of course, two facets that are available on the table, which is arbitration and mediation, and of course, there's conciliation.
Anu,
And what is
Come a
conciliation?
little this side. She's not in the frame.
Arbitration and mediation.
You're in the frame. Acha, no, come.
No, I think this is fine.
I think if you're this side, I think you will be in the frame.
All right, I
The
will
more you are that side. Oh, is it?
Yes, yes, yes.
Yeah.
So, between arbitration and mediation, do we see a lot of IP disputes entering the field? Yes, we do. What is the structure? What is the capacity that we have for these two in India? As far as arbitration is concerned, we do have a central legislation that dictates how it goes. Institutional arbitration, that's something we're seeing some growth in. For mediations, we've had mediation for IP from what I remember, 2015, 2016, we have been mediating. How? The Delhi High Court set up its court annex mediation center called Samadhan, came up with its own procedure. And the big push for mediation did not start from legislation. I mean, of course, we've had the Code of Civil Procedure in Section 89, which talks about refund of court fee, which is a good carrot to put in if you're going through alternate dispute resolutions. But the real push we saw was from courts, because the courts are burdened. The number of matters is intense, and that of course has continued to grow. So the real push towards mediation, at least, we saw from the courts, where the establishment of court annex mediation centers was a big boon, and how matters were funneled into that system. And then these mediation centers were not manned in an untrained manner. So we have today some of the most skilled mediators are senior counsel who were trained in mediation, and they now are appointed as mediators, and that number and the roster of mediators is of course increasing, and there are more people being added to it. That is a capacity issue. Right? There are more matters going into mediation. Is everybody excelling as a mediator? Is a question. Do we have sort of diverted a lot of matters there? Are we able to handle them? And now, are we trickling down matters even for mediation at district court levels? Yes. Do we have capacity there? My frank assessment is no. When you handle mediation at a center versus another center, you see the difference in how it's handled.
There's a qualitative difference.
There's a qualitative difference, and it's not marginal. So I think that is where some focus needs to be as far as the capacity is concerned. Why is it successful? I mean, I think it is successful, at least in my practice, because, well, courts direct you to mediate. Now there is a push in legislation under the Commercial Courts Act, under 12A on pre-institution mediation, which has funneled its own litigation, unfortunately. The idea of 12A was
Yeah, we'll touch on that point,
yes,
because
to
it's a more
avoid,
substantive point.
exactly, to avoid, but it
Yeah.
has opened its own set of litigation, maybe for the short term and not for the long term. But the idea remains that we will need more capacity as we are going to encourage people to mediate. Incentives such as refund of court fee work very well, especially in those disputes where refund of court fee is a big deal in terms of the outcome achieved. So there will be lots of cases which shouldn't have languished in litigation for as long as they did, and a close resolution plus refund of court fee sort of satisfies, at least the right holder. So those kind of cases, yes. I'll just add one facet in terms of cross-border and the kinds of disputes we have seen being resolved in ADR. A lot of ACP disputes have gone to mediation in India, and not now. Our Delhi High Court Mediation Center has been dealing with ACP disputes since 2016 and has had successful outcomes. And we've had outcomes where there were foreign right holders, Indian implementers. We've had successful outcomes, foreign right holder, foreign implementer, and that way. So I think we've seen good success, but to make it last and to support the numbers we are talking about, we don't have that capacity.
Yeah, the problem of capacity is very huge. The problem of capacity in the judiciary has been shifted on now to the problem of capacity in the ADR system. And this is quite visible because we have 50 million cases. What is 5 crore? 50 million? 50 million cases pending at all levels of the courts in India, right? In the Supreme Court itself, 80,000 plus cases are still pending. But the elephant in the room as far as intellectual property is concerned is the very question of whether that subject matter of intellectual property is arbitrable or not. And I think we can begin the discussions with Udita, and then we can ask Adarsh and others to sort of pitch in. Udita, would you like to start with the question of arbitrability?
Good evening, everyone. I'm a litigator, IP litigator, so it is, and belong to the adversarial system rather than the ADR system as such, and arbitration as such. But there are a lot of copyright disputes right now, presently, because they involve license agreements, which we are seeing in arbitration. Coming back to whether IP disputes as such are arbitrable or not in India, there has been a contentious history. Initially, if we go back to before the Arbitration Act came in 1990s, there was a very famous Delhi High Court case, Modi Mundi Pharma case, where the court very categorically said that IP disputes, because they are governed by IP statutes, the remedies lie for adjudication by a civil court. So there was no arbitration allowed at that point of time. Then came, and in fact, till 2011, till the Booz Allen Hamilton case of the Supreme Court, the state remains so. In fact, even after that, for some years, it remains so. In the Booz Hamilton case, the Supreme Court basically looked at arbitration from the context of rights in rem and rights in personam. And when it came to rights in rem, it said yes, you have to, basically they have to be adjudicated by civil courts. But it did draw out a important exception, that is where in cases which involve subordinate rights in personam, which arise from rights in rem, in such disputes, these disputes can be arbitrable. So this is where we got a little bit of IP arbitration coming into IP disputes. Thereafter, there was this was followed by Justice Patel of the Bombay High Court in the Eros International case, and very succinctly he basically stated. He followed the judgment and basically said that copyright infringement disputes which arise from basically a license, a copyright license, they are arbitrable. He also said that the the statutes, the Copyright Act and the Trademark Act, does not oust the jurisdiction of arbitral tribunals as such. Thereafter, what happened is there were Supreme Court judgments, two of them in 2016. There was also the IPR's judgment 2016, which muddied the waters a little, which again said broadly categorized IP disputes as being non-arbitrable. The situation remains so till the Vidya Drolia case of the Supreme Court in 2021, which basically laid down 4 tests as to why, what kinds of disputes are non-arbitrable. And very interestingly, it is also laid down that when it comes to registration of trademarks or grant of patents, those are subject matter which cannot be arbitrable. That's rights in rem specifically, and that's monopoly rights. So that is something that can only be adjudicated by civil courts. Now, this ratio was taken by the Delhi High Court in the Hero Electric case by Justice Hari Shankar, and he basically laid down that when you have IP assignment issues which are coming up from family dispute, this was a case of the Hero trademark dispute. Munjal. In fact, Munjal cases, there's another case in 2022 where Justice Bakru gave the decision. And both of them basically saying that when it comes to IP disputes which are rising from family settlements, IP assignments, those issues can be arbitrated upon. And also, I think that's also been followed by the Golden Tobacco case of Delhi High Court. Now, what is arbitrable, what is not arbitrable? What is arbitrable is when you have a contractual or a commercial arrangement arising from IP rights, that's what is arbitrable. But when it comes to core statutory issues of grant of IP rights, whether they're valid or not, that remains with the civil courts, the IP tribunal as such. Also, when it comes to infringement issues, when you allege infringement, the opposite party always alleges invalidity.
Counterclaims, yeah.
Yes, counterclaim of invalidity. So those we don't see going into arbitration very soon.
So what then are the gaps currently, in terms of the question of arbitrability? Because if the issues in relation to validity, issues in relation to other aspects which are in rem cannot be decided, there could be still potential for a lot of disputes. I can, think not just in terms of licensing, but in any other cases that could be, sort of put together as part of arbitrations. What do you think, Adarsh? Because you have some experience in, doing a lot of experience in doing arbitration, in particularly in life sciences. What do you think were the challenges you encountered?
One issue is what Udita is saying is the law seems to very clearly indicate that if there is a contract, the contract may involve IP, but if the dispute is on the contract, it's arbitrable. If the dispute concerns the validity of the IP, that is non-arbitrable. Infringement is a curious problem because there are observations in Justice G.S. Patel's judgment which says that technically infringement is in personam because it's a finding that a particular party is doing a particular act which amounts to a violation of that particular IP. So it is an in personam finding, it is not an in rem finding. So his indication seems to be that it's an arbitrable issue. But if you take it from that angle, because even if you, for instance, you take a typical contractual dispute where the IP holder says that you have used my IP and you have not paid me. It's the most simpliciter licensing dispute you can have. What if the defense of the defendant is that no, I have not used your IP? Take a simple case of a trade secret that according to the IP holder, I have provided you this item 1, which is the trade secret. The defense of the defendant is, no, I am not using IP1, I am using IP2. You didn't give me that, that's my own, right? The problem is you'll have to determine the scope of the IP. By definition, the scope of the IP will become in rem. For example, it's a patent dispute, you'll have to determine the scope of the claim, which is by definition in rem, because the scope of the claim cannot vary from one infringer to another, right? Take another instance. Assume infringement is therefore arbitrable, right? Or a licensing dispute is arbitrable. In India, at least my understanding of the law following US Supreme Court is there is no licensee estoppel, which means even a licensee can question the validity of the IP that he has taken license to. That's the common law position today. So if the defense of a licensee in a particular licensing dispute is, well, I don't need to pay you royalty because in my view, you have licensed something to me which is invalid ab initio or void ab initio in law. So his defense is that the contract itself is void for licensing something that is non-existent in law. But that's an in rem question. So if that dispute goes to arbitration, the claim of a claimant can be adjudicated because it is in personam. But the defense of the respondent cannot be arbitrated because it is in rem, which means you'll split the proceeding.
Although some of it is not related to validity at all.
Nothing.
Because you have to determine scope.
But Vidya Drolia says, ergo omne, anything that is either ergo omne or either in rem, both categories are non-arbitrable. So in which event you will have a split decision where the tribunal will only say that all right, I am only ruling on whether you are doing something covered within the scope of the IP and the license, and therefore you are liable to pay so much amount of money. Your defense that the contract is itself void because the underlying IP is ab initio void, I am not ruling on that. Now when the successful claimant goes on, wants to enforce under 36, in a domestic arbitration, and the unsuccessful respondent files a 34 challenge saying that my defense is unadjudicated, what if you today enforce the award and 5 years later in a rectification or a revocation proceeding the IP is held void ab initio? What do I do? What is my remedy? That would be unjust enrichment. So this is a practical issue we face. We had that in an ongoing dispute. COVID made the parties settle, so unfortunately we don't have a final finding on that from the Bombay High Court. But this is a real practical problem. Now US has taken a very unique approach because in their statute, for instance, you take the patent statute, they specifically say even invalidity is arbitrable. The parties can consent to arbitrability of even the invalidity with the caveat that the finding is in personam, the patent will not be revoked in the register. But between the parties inter se it is void. The patent is not applicable between the parties, but overall the patent still remains, which is
a good position to have actually.
Potentially, but from an academic perspective, it seems to be a very funny way of looking at it, because you have an adjudicatory body, whether it's a court or something else, a legitimate adjudicatory body determining that the IP is invalid. And here it remains in the register. And the basic principle of, if you remember Supreme Court's judgment in Hardy, citing, of course, it's on the trademark side, but it says that a rectification proceeding is in public interest because it is to maintain purity of the register. So having an adjudicatory body determine that an IP is invalid and yet hold it to be an in personam fighting that does not affect the actual registration itself is also an odd position if you see academically. But that's the solution they seem to have come up with.
And with confidentiality, I don't even know how anybody is going to know that particular IP has been invalidated.
Except if there's a challenge.
That's, of course.
The moment there's a court challenge, which
Then,
is bound to happen in most arbitrations.
Switzerland, Belgium, Germany, all of them follow that
Yeah.
because of the confidentiality of
Right. But the moment you do a court challenge, it is in the court record and there will be an order passed saying that, well, the patent has, you have to record the contents of the order in a judicial
Absolutely.
proceeding.
Absolutely.
So it will come out in the public. So I feel that as far,
In certain jurisdictions, you can even contract out of an appeal.
yes, you can
Or
contact.
the
you
blanket
can.
of confidentiality can remain.
So I feel that there are very tricky issues. For a lot of people who are in practice, when we are in the day-to-day grind, including people like me, I've had days in court where I feel, yeah, we should just go to arbitration now. It's not ending here, it's going on forever. But then having gone through arbitration proceedings for IP, there are some very tricky points. I don't have to think about all that in court. Because everything is open in court, I can fight out every point. But I cannot do that in arbitration. And mediation, well, I'll wait for the other question. I have my own problems with mediation in IP.
Well, on the arbitration, and I just had a question. Sometimes when I, hear about arbitration IP, I ask a question to myself that, see, the objective of ADR mechanism is to save cost, to save time, right? So when an IP dispute is taken to arbitration, and vis-a-vis, there is a separate channel, and we have a court, stream for adjudicating the IP disputes. Well, after the arbitration is done, again you have to go through section 34 and then 36, 37, isn't it? And then ultimately the issue lands up in the court for again the adjudication, right? So if that is the case, then why not, take the court route itself and then try and adjudicate the IP dispute with the judicial intervention rather than going in for the arbitration. This is one of the questions which I asked myself because I have never done the arbitration of IP disputes.
At least the high courts could directly deal with both the questions of infringement and validity.
Especially with the IPD
they are doing
mechanism.
that.
Yeah.
One difference.
If you remember, when the original customs rules were created for enforcement of IP,
Patent.
they deleted patents
Yeah.
by amendment later.
Yeah.
And the specific reason was the division bench of the Delhi High Court had said, what if the importer wants to challenge the validity of the patent? The customs does not have the authority. So how can you leave the importer defenseless? So ultimately that led to, in principle that applies to trademark also. But for whatever reason,
They withdrew the patent.
issue went to court and therefore they withdrew. The same point, right? You don't have the authority to adjudicate the defense. So why bother put it at all in an enforcement mechanism? The same logic applies to arbitration also.
Which is a little different in other, I think, jurisdictions where they have both infringement and validity. I don't know about the customs though in the US whether ITC.
No, the problem is our rules are framed very differently because there the customs will only interdict for 10 days. The customs officer will interdict for 10 days or 15 days, I forgot the timeline. But the matter goes to the ITC, which is an independent adjudicatory body. In our Indian rules,
Yeah,
there is
we
no
don't have-
independent adjudicatory body, it's the customs itself adjudicating, which is where the big question mark arises. And that's something that Nidhi ma'am was just in the beginning, you were talking about the arbitration council. As a practitioner on the arbitration side, every time I step into an arbitration, in all honesty, I must admit, we always walk in with a trust deficit as far as India is concerned. And the reality is, particularly for institutional arbitrations, everybody is concerned about power play. And that's I find it a big question mark because to me, maybe it's my psychology or maybe it's a psychology of every person who's, started litigation in court. At any point in time, I'd rather go before a judge for an appointment an arbitrator rather than an institution because I have a trust deficit issue.
Yeah.
But maybe it's just me.
Yeah.
No, I don't think it's just you.
But with this problem of trust from your side and capacity from the other side, I don't know. I mean, with the Mediation Act and making mandatory, making mandatory in the Commercial Courts Act 12A, how does it look like? What does the situation look like, particularly for IP disputes, where in every other case you have a question of interim remedy? I don't know, apart from maybe Fran, that also, is very, arguable whether it's a money suit or whether, you really want to stop someone from, from
Well, a
using the
division
technology.
bench does say irreparable harm.
Yeah, so that's the reason, because when there is irreparable harm, it means it's not merely a money suit for, determination of royalty. So in which case, what do you think as experts in this field in terms of pre-litigation, mandatory pre-litigation mediation, and how it is panning out? We can start with Aditya or with anyone who wants to join. Aditya, you want to say?
Happy to start. So I think I want to kind of deal with it in two separate parts. One is pre-litigation, and the other is mandatory. I think they are two separate themes altogether. According to me, making it mandatory is not a bad thing. I think, especially in IP disputes, it's a good thing that people are put into a particular framework where they are being asked to see whether it can be settled. The framework is such that you are outside the contentious framework of courts. You are before a center, you are hopefully before someone who's trained at helping parties resolve their disputes. And there is, of course, one view that can you force parties to settle, right? As in, mediation should be mediation by definition is a voluntary mechanism. You shouldn't be asking people to, or forcing people to go for that mechanism. Having said that, I think many IP disputes are capable of being settled, and very often, because it's not a contractual dispute, you have had no previous transaction with that party. It's not a family dispute. You don't know your counterparty at all. So the trust deficit is very, very high, which is why it's very difficult to know at the beginning of a dispute as to whether or not how the other party will play in a litigation, and therefore you don't know whether to mediate with that person or not. Therefore, being put into that room and being asked to try and see if it can be resolved outside of a contentious framework, I think it's a positive step, should be done. According to me, the more troublesome part sometimes is the pre-litigation part. Of course, the pre-litigation has a very clear logic. We want to unclog the courts. So therefore, try and do this before you are asked to come to court. But I sometimes really wonder if it is the most conducive time to actually ask parties to settle. Parties haven't rolled the dice. They don't know how it will look in litigation. There's been no court adjudication, so they don't know as to what the merits and demerits of their case is, whether they'll likely win or lose. Many a times parties have no sense. They are being advised by lawyers, but they believe very strongly in their case, irrespective of the actual merits of the case. And therefore, sometimes being asked to try and resolve something before any sort of adjudication on the core issues can not be a very conducive environment to settle, because parties end up then starting talking merits during mediation, which is the least helpful way to mediate. So I think the process of mandatory mediation helpful for IP disputes. I don't know if pre-litigation is the way to go for it. I think what's really effectively happened, at least I can speak for the Delhi High Court where I practice the most, that courts have basically found ways to make the system work where they will exempt most parties from engaging in pre-litigation mediation, except in those cases where on the first day the court feels, look, it's a family matter, or it's a matter where it's very likely to be settled if it's sent to the mediation center, and people should not be kind of put through the court process before they try mediation. So you've created a mechanism where you don't go through the court process. You go through the mediation process. If it doesn't work, you come back to court. But in 95% of the cases, the court says, look, according to me, this is really not going to work out. Let me adjudicate first. And then very often, after there's an interim decision or something like that, the court will ask the parties to go to a mediation center and transact.
To add to that, Section 12A says urgent interim relief. Yeah. Now, what also happens is sometimes in STP litigation, parties have already negotiated. There's a different thing when the parties themselves enter into a pre-litigation mediation. But when they have come and chosen litigation, they have already gone through the negotiation. Now, because there have been a particular time period spent in negotiation, if you bring in urgent interim relief, there is nothing really urgent. Yes, the negotiation has not happened, that's urgent enough, but sometimes it's very difficult to explain to the court that yes, cause of action arose on a date, we've been negotiating, and we've not reached a settlement, and therefore we want to come back. There are some judges who might feel that that's not urgent enough, you go back to
But
pre-litigation.
I mean, the flip side to that is, look, this hasn't been solved for
For
5
4
years.
years. The
So
average.
therefore, you mean I should wait for another year,
Another year.
Yes.
before I solve
Exactly.
this? So there is now urgency why I
No,
must
so
come to
there
court.
have been cases where that's been argued, but it's not been, the judges have not taken.
I think we can ask Ashutosh what has been his experience in this friend disputes. But we'll tie in the 12A question again and also take Ashutosh's view, and then we'll come to Adarsh Brijesh on the 12A question. Ashutosh, over to you on friend arbitration. What's happening?
Thank you, Yogesh, and good evening, everyone. Yogesh, if we'll talk about the ideal word, ADR is a very good thing, and all benefits which Mr. Hellman highlighted applies to the SEP and FRAND dispute as well. Cost, timeline, global solution, and all everything. But we don't live in the ideal world. And in my limited experience of litigation, especially in the SEP and FRAND, I can tell you that mostly litigation is actually being used as a proxy for negotiation. When parties are in litigation, they're actually negotiating. They're testing the waters, testing each other's bargaining power. And unfortunately, mediation has been used as a tool or part of litigation strategy to create more delay. And this Supreme Court ruling on Section 12A and making it mandatory, and there's something where I disagree with Aditya, that making it mandatory something has created more problem. Because you take out past 2 years, first order of every SEP dispute in Delhi High Court, and you'll say the one of the major defense every implementer has taken is the suit itself is not maintainable. And the court has to now invest some more time on Section 12A issue. So these are the challenges which I see, although ideally, it's a very good thing. And especially, let me tell you, an SEP and FRAND dispute, it's not that every SEP license is FRAND license is a result of some litigation or some kind of arbitration. 90% of FRAND license results from bi-party negotiation. It's only in 10% cases parties litigate. So it's not that in every FRAND licensing, it's the lot of dispute in the industry. So in this 10%, as Udita mentioned, Abhilash also touched upon, that parties have already spent like 4 or 5 years in negotiation. Then coming in court, and after that long period of time, if someone is deciding that, okay, now there's no other option left, I have to litigate now. And then someone saying, okay, no, send the matter again for mediation. It's a non-starter.
Yeah.
So it's become a checklist.
Yeah, it's become.
Checklist.
I honestly feel that Section 20 of the Commercial Code Act is a joke.
Sweet people now.
It's a joke on the world, it's a joke on litigants, and I think it's a joke on the courts also. Why? Because I don't think even courts take 12A serious. Your typical order granting an exemption from 12A. And I'm saying not because it's plaintiff or defendant. I think for both plaintiff and defendant, it's a joke. Because courts typically are granting exemption for the asking. Although Supreme Court says, although dominus litis, plaintiffs will decide what is urgency, it is not an absolute unilateral right of the plaintiff. The court does have a role. It's not the same standard as deciding an injunction, but that's something to be examined.
What's then the standard? Because you will have to look into the question.
Para 10, para 11 of Yamini Manohar says the courts will have to examine the plaint and the documents if the urgency is a quote-unquote camouflage. That's the test.
Camouflage.
And whether through deception a plea of urgency is being taken to circumvent 12A. That's the test. Question is, how do you apply it?
I know.
Right?
Frankly.
And the court also says the negative. The court says the test is not 39(1) and 2 injunction.
Yeah.
So they've given the negative, that what is not the test. The test given is that examine if it's a camouflage deception to circumvent. which is as open-ended as you can get in litigation. And the practice is that a 12A exemption from pre-litigation mediation is granted in one line in every order for the asking. There are only very, very exceptional cases, some of the cases like Aditya was pointing out, that I've actually seen courts take a pause and say, it's a family dispute, all right? Why don't you guys talk it out? But I think family disputes are maybe 0.1% or 1% of the total set of litigation.
And heavily in trademarks.
Correct. So I feel it's not even a sample to be considered, right? You remove, it's an exception to the rule, it's an exception that proves the rule, which means in 99.99% of the cases, 12A is a joke. Your Economic Advisory Council says 12A is a joke. And yet we want to retain it because I have had cases where, obviously when I argue for a plaintiff, I'm very happy. I say, well, not the urgency, your lordship's consistent practice, and this is granted. When I stand up for a defendant and say, why are you granting a 12A exemption? The typical reaction is, don't you have more substantive things to say? Why are you on technicality? The fact of the matter is, the Parliament has said it's mandatory, Supreme Court says it's mandatory, that a suit that violates 12A is barred by law and therefore to be rejected under 711. All of that exists theoretically. Ground reality is nobody takes it seriously. So my sense is mediation may be good. It depends on the facts of every case. But making something mandatory is not benefiting anybody. Other than, as you rightly use the word, it's a checklist. So everybody makes sure there's an application filed or there's a paragraph in the plaint will say, urgent relief, therefore give me exemption, which is anyway granted for the asking. I'm told, however, there are instances in the Calcutta High Court where Calcutta High Court has a procedure, because it's one of the chartered courts. You have to take leave to sue. You have to take leave to sue if the defendant resides outside of Calcutta.
Even Chennai as well.
Even in Chennai. Yeah. So in Calcutta, I'm told there are orders where after the 12A exemption is granted, the defendant enters appearance and applies for revocation of leave to sue for violation of 12A, and the Calcutta High Court has revoked the leave and sent the parties to mediation first.
An instance from Himachal Pradesh.
Himachal also, yes.
And that's
Himachal.
now in the Supreme Court.
See,
And that question, I think, is the question that will balance it. What is the point of 12?
That's a case
last week
we are handling that case. I was about to mention about that case only because see, there is a distinction here between Delhi High Court and other high courts in the country. I have a feeling that, as Udita and Adarsh mentioned, Delhi High Court is not giving much importance to Section 12A, and they focus on the substantive infant reliefs. In fact, they don't want to waste time in for discussing about 12A. That's a feeling as a practitioners we have got. But courts outside Delhi Infina have taken Section 12A, Yamini Manohar, and also I think the other case in Bombay, and even the case in the case decided by Justice Harishankar on 12A very seriously, in the sense that Shimla High Court, after exchanging couple of correspondence, of course, in IP, objective is to send a C&D and then try and cease and desist letter and try and settle the matter, right? So in one of the patent cases, we sent is a cease and desist letter. There was correspondence between the parties. And then when the suit was finally filed, the Shimla High Court took the view, the defendant, filed a Section 12A objection. And the Shimla High Court took a view that, correspondence have been exchanged between the parties. And this is a fit case for, a pre-suit mediation. Even though, urgent reliefs, were sought in the plaint. And also, as per the settled position, that the court has to see whether the plaint discloses urgent reliefs or not. And the court cannot go beyond that into the merits. So, but the single judge dismissed it. We went to DB. The DB dismissed it, and now finally into the matter is in the Supreme Court, and a question of law has been framed there that whether if pre-suit mediation Section 12A has not been complied with, does it entail a complete dismissal of the lawsuit, or should the parties be sent back for mediation? So that is a question of law.
The Supreme Court in Patel Engineering clear that if you violated 12A on facts, then 711 suo moto applies, and suit is barred.
Exactly,
the plaint is rejected.
But in whether it should the parties has to go back for mediation, if that is a correct position or not.
Or it's a 3-judge bench.
I don't know.
3-judge or division?
Two,
Because
division.
Patel is
This
2-judge.
is two.
Just to add
This 2-judge bench.
add to what
Yeah.
Ashu-
But here the parties have also been sent to mediation while this question has been framed.
So
Yeah.
just to add to what Adarsh and
Exactly, yeah.
Adarsh was saying, there was an SCP case before the Delhi High Court where Section 12A was argued at great length on very strenuously by both the parties on the first day, and on the second day the court went on ahead with the 39(1)(a) application and arguments on injunction, interim injunction, keeping the 12A pending. So the 12A is pending and interim injunction is being argued. So there's no sense of Section 12A then.
Yeah, in fact, I've had a case where injunction granted
12-way pending
and party sent
to mediation.
to mediation under 12A.
I think overall,
And
look,
if I can give you an example,
That's not 12A. That's practically they send to mediation.
yeah.
You can put it as
I
12A.
can give you an example of a case where 12A was dismissed, exemption application, and injunction was granted. So the court has dismissed the 12A that no exemption is not allowed. You have to go for pre-litigation mediation, but with injunction.
Ashutosh, you are for one of the parties.
No, actually, I was sitting as an audience in that case.
Also, just excuse my ignorance, but in IP disputes, isn't it what is most vital is injunction or the interim relief?
Interim relief is
Then how relationship of 12A with respect to IP disputes seems more questionable.
No, we should just drop it. I think we should be very clear in our head. Parliament should be clear and say just drop 12A, at least for IP.
For IP,
I mean,
yeah, maybe.
Retaining it and giving it stepmotherly treatment makes no sense. You might as well just drop it.
I think there is a version of 12A that to my mind will make sense, because I have seen mediation be successful in a certain fact situation, and that fact situation is pretty rampant in IP disputes that end up in court.
No, I agree with you.
So there must be a version of 12A.
I think the judge who's hearing the matter is in the best position to
Exactly.
take that call.
Correct.
Exactly. I fully agree.
So I think the version of 12A perhaps that even I will not consider a joke is an amendment to the CPC or 12A itself, which says on the first day of the listing of the suit,
Exactly.
the court shall consider.
But that was
Case
actually
management.
Exactly.
mandate
That's what
under
we were discussing.
89 CPC.
Like a case
Exactly.
management.
Exactly the mandate of 89.
Yeah.
Management sort of a hearing on the
Yeah.
first day, and whether this is
That is
litigation.
the only version I see making sense
Exactly.
because the judge has an idea of.
That's right.
What should happen?
Then we
And-
might as well do it with the current law in CPC rather than.
No, actually it was not
And the
needed.
Supreme Court is going to answer this very question. So effectively what the Supreme Court has framed will translate into that evaluation for the judge to decide at the first hearing, is this a case that should go to mediation or should I issue summons and then proceed?
Which isn't that
Which
what
may
is
be
practically happening?
inconsistent. Exactly. That is
And
what
if
is
I can
happening.
just add one more suggestion on 12A.
Where it appears to the court that there exists elements of a settlement
Yes.
in 89.
No, and I'll tell you, when the mediation bill came, maybe I'm wrong, somebody here can correct me. The bill originally said mandatory mediation. The committee says, I'm sorry, it doesn't
yes.
work.
Yeah.
So they made it voluntary. So I think everybody acknowledges that 12A needs to kind of go away somewhere.
I think what 12A has introduced is that, look, it is coming in for sure at some stage of the proceeding, and 12A says pre-litigation. Pre-litigation, my sense is not the section where you make it mandatory, but the fact that it must be spoken of in a litigation and not be completely left to someone's discretion, I think that's positive. That it should come up at some stage in that litigation. And unless it's mandatory in that, in that regard, it's never going to come up in the lifetime of the litigation.
So like CPC should say on the first day of the court shall
Yes.
consider.
That's 89.
Some application of
But I think it's a
It
more
appears to the court.
It appears to, but it has been AFCON says it is shall.
correct.
something
Which
in,
may be acceptable.
I mean, of course, that's not a language that's evolved with the times. But in the UK courts, for example, if you go for litigation, you have a pre-litigation protocol, somewhat of a checklist. But you do that. Parties are supposed to put that in when they file for their suit, saying we've followed the checklist, we've done this protocol. The protocol requires us to discuss or even put to each other the possibility of mediation. If you want to participate, great. If you haven't participated, at least this is where the parties stand. We are before you. So there's no question of you now taking on the burden of judging whether we have to go to mediation or not. So that's how they do it.
I don't
Not
think
necessarily.
I think there's
Not
a big
necessarily.
difference.
Maybe not for IP,
But there's
not
a big
necessarily.
difference, I think, in terms of our approach to mediation and our experience in mediation and how advocates approach mediation and how litigants approach. And again, going back to the capacity point,
Yeah.
we don't know
That
the
tells you
tool,
what
how to
happens
use
in
it.
mediation is also now equally important, because if there is a serious capacity issue, then particularly in complex disputes like patent infringement and these disputes are very complex. But before we move on to
Yogesh, just Section 12, we just wanted to add one more suggestion. Till the time, ideally, I also agree with everyone that it should go. And if legislature is not repealing that provision, then Supreme Court should revisit its judgment and then clarify that it's not mandatory. But till the time it's there and the Supreme Court judgment is there, maybe perhaps what courts can do, they can prescribe some kind of a fixed timeline or some very short timeline. If it's in a time-bound manner, maybe perhaps the misuse of 12A won't be that rampant as it is now.
What has
So,
been your current experience? How long does it take if it goes into mediation?
to be very frank, Yogesh,
Pre-suit mediation or the mediation? After the
no, in
issuance
cases
of
where I've gone through pre-suit mediation, typically in 1-2 sittings, it's the
Because the parties
in
have
fact,
actually
Yogesh,
made up their mind. They want to
They
litigate.
want to litigate, and
if parties are
particularly when
sorry.
parties are going at length, particularly the plaintiffs are going at length to camouflage the names of defendants,
Yes.
to not make sure that they are not big companies and the the representatives of the companies, and in their names the suits are filed, right?
now it's stopped.
And
Now stop.
Has stopped?
Yeah,
That's
it
good.
has
Yogesh, I
stopped.
can give you an example.
That's the only
Never
case
seen
for
it when I put a stop to
counterfeiting.
it.
I think that's the where you get the leeway. In counterfeiting suits, there you may you can
Now you need to seek leave of the court to mask the
yeah
name.
mask the name. But what you can
The
do
courts
is you
need to
can
mask.
keep the first name as the director's name or whatever the partner's name, and then in the first hearing say that we have done that because it's a counterfeiting suit.
And Yogesh, I can give you an example, that even in complex cases, like we had one case in SEP, it was related with SEP only. And initially the court sent parties for mediation and parties were like kind of negotiating for 10 days and no conclusion. And then matter came back before Justice Badar and he made it very clear that no, either you do something or I will rule on next day. And he gave only like few hours party to negotiate and settle the matter, and party settled it. So if parties have both have a bona fide intention of settling the dispute, few hours is sufficient. We don't need even days.
Yeah, so I think I'll speak to just one thing about what Ashutosh's point, and this I think is the biggest drawback of the mediation setup that we have in our country, is the date that we get. It will go on Monday, then the next date will be after 3 weeks. If we are really mediating,
Ex parte injunctions with returnable date in 6 months.
Yeah.
yes, and no, even in I'm talking about
For
the
vacating.
mediation context.
Yeah. Ex parte injunction granted, pleadings to be completed, come back
But they
after
can
6
file a
months. That's a
39-4.
returnable date.
But they
That's
can
the
file a
returnable date.
39-4.
Of course, they can come to court.
But 3 weeks is
But in
like
mediation,
3
the
weeks, I
mediation
think
has
it's
to
quite-
happen day to day or
Yeah.
morning to evening, one day.
3 weeks
That's
is quite
it.
normal. I think in
You're going
Delhi
to
High Court.
settle or not settle, but for us, we get dates after 3 months, after 4 months, or something like that, depending on the mediator's availability.
Yeah, but just one point here, and fair, see, earlier on, I think just before Arishankar's decision, that even during mediation, the parties were supposed to complete the pleadings, and for example, the written statement, you need to file as per the CPC 30 days time, extended by 90 days time, right, 120 days. So you're supposed to file your WS even during mediation. Till Harishankar stepped in, I think last week or 2 weeks back, and he gave a judgment that the period of mediation should be exempted from filing written statement. So which is a big relief for the practitioners and for the parties. Otherwise, on the one hand, you focus on the mediation, and on the other hand, you also focus on completion of the pleadings, that is filing a written statement.
This will disincentivize plaintiffs for exploring mediation because
Yeah.
they're going to view
Absolutely.
it as that now
Delayed
there's
tactic,
pause.
yes.
This
Yeah, but-
120-day pause. This mediation will definitely go on for
For
120
This
days.
may lead to some more new kind of a misuse of pre-litigation.
Come again, Ashutosh, you were saying something?
I'm saying this interpretation of Justice Harishankar may create another kind of a misuse or mischief in terms from the defendant side, because they will say that okay, we are in mediation, so extend my time to file written statement.
Because there are many times when you go for mediation,
Becomes,
the opposite
so
party
mediation becomes protracted.
And I'll tell you
Yeah,
that
this is a Bharat Singh case.
Bharat Singh, and
Yeah,
because we are an academic setting, I have a respectful disagreement to that judgment, because Delhi High Court has already taken a view that even a 7-11 application
will not.
will not pause the 120-day period, and that's a consistent division bench view. So
The contract also says so. Just
Correct.
Nariman says.
Decision.
So in a situation where even a 7-11 where the suit is barred, application for 7-11 saying suit is barred does not pause 120 days. How can mediation pause 120 days? I have my doubts on the correctness. I sympathize with the view because I think it makes sense at some way, because you can't mediate and litigate.
Exactly,
It
that's a
doesn't work
logic.
that way.
Yeah.
But anyway, from a legal point, we'll have to
Yeah,
see.
but then how does ADR become attractive for foreign investors in in India then with this India International
I am
what is
trying
it?
to
India International
I am trying
Arbitration.
to enforce a foreign award in a high court without naming parties or court. I'm waiting for a declaration that it's a decree for the past 8 months. I still don't have a Section 47 order in my favor. It's a Singapore arbitration. Waiting for 8 months. I still don't have a declaration that it's a decree, which means I can't even file my execution petition. That is the reality.
And
Other thing
Yogesh,
is that you get 120 days to file a written statement, while only 45 days for your replication. So if the parties have to settle, I think there is enough time for the parties to make up their mind within that 120 days of
Correct,
mediation.
correct.
For the filing of the written statement, because we get only, if you the plaintiffs get only 45 days thereafter, in fact 30 days plus 15 days to file
If
their
there is intention to settle,
replication.
it will anyway come up.
Exactly. That is the point of mediation.
Yeah.
I think mediation, my personal thoughts on this are must be encouraged. Is 12A the correct mechanism of encouraging it? Perhaps not in its current form, but it's definitely a tool that should be encouraged. There should be more training. Lawyers should be trained so that there is greater appreciation of how to use this tool.
I think it's just me. I don't think I've had a single dispute where I'm a counsel to settle it. So maybe it's on me.
Yeah,
So it's a fantastic tool if used right.
yeah.
40,000 cases have been referred to the Samadhan, which you mentioned in the Delhi High Court Mediation Center, so far. And almost, I think, 1/3 cases in Finland have been settled. So
And
around
the
roughly
Samadhan annual report
13,000.
has the statistics.
Yes.
And 2017, the stat for IP says 100% success
That's
rate.
right.
Now I think it's 80 to 85.
It's very
Yeah.
high. It's very high. So those stats speak of the value of this tool.
Are these
My
stats
doubts on the
believable?
status.
But
Yes,
if you
yes.
torture them, you'll find out.
Yeah.
If you torture the statistics, you'll find out how many disputes actually were.
This is generally after the grant of an interim injunction.
Yes.
So after the grant of interim
That's the
injunction,
catalyst.
that's,
Changes,
yeah.
na, yeah.
So you are settling under the shadow of an injunction.
Yeah.
Under the Ashutosh, under the threat of an injunction. So okay,
the very grant of patent creates that threat. So every patent dispute is settled under the threat of injunction.
absolutely, absolutely. I agree with that, except where there are. Well, let's not go there. But moving on to another critical area, because there most of these disputes are cross-bordered, and sometimes even outside private arbitration, there are challenges for IP holders, particularly when it comes to how the state regulates intellectual property, and then we have investor-state arbitration, etc. And the experience generally has been now, at least as far as we know, that it has not been so IP friendly. Philip Morris or other cases also in the NAFTA Eli Lilly dispute also we saw that. So what then is the future for that kind of arbitration, because there is everybody thought there was quite some potential, but then nothing happened, and that I think also determines how the IP ecosystem in any particular national territory shapes up, because there is always a stress and a pressure towards compliance with international treaties. Manu, let's start with you.
Right. So, in investment treaty arbitration, which is a completely, public international law in general is a completely different universe in the way it works, like all of us know. And I'm so happy when everybody discusses judgments with judges' names, and he said this and Akru said this, and so clear, and there's stare decisis, and everything is right there. But that's not how this universe functions. The universe is hierarchical. There's no question of precedent. Yes, there's a general consistency to be maintained, but there's, it's a different beast in itself. And while there are some benefits to investment treaty arbitration in the sense that investment can be anything, and it's usually defined as including intellectual property, there's a problem there, because there's a test for investment, which is a generally accepted test of what is an investment under investment treaty. And that investment must have 4 elements to it, sometimes 6 if you take some other cases. Those 4 are that you must have contributed capital, there must have been an assumption of risk with the expectation of profit, and you must have contributed to the economic development of the host state. And then there's a territorial element, that the investment has to be in the territory of the party, one of the parties at least. So in this case, what happens is sometimes I believe it doesn't mesh very well with what we consider as investment, or you might consider as investment in intellectual property. For example, there was this case of Apotex v. US, Canadian pharmaceutical company, suing the United States under the NAFTA around 2006, I believe. And they said, well, you've rejected our marketing approvals for this particular drug. Generics have taken over market share, and we've lost out for these 12 months, 18 odd months. And this rejection was unlawful. So now you pay us what we should have, our market share was really high, you pay us the damages now.
It's a case for regulatory expropriation.
Regulatory expropriation. They said, you've taken it away. We had, and the question was, they said, what did we take away? They said, you took away our right to sell and also our intellectual property. They made the claim that way. And the tribunal said, well, there was no actual investment that inhered in your intellectual property that was developed or had been made in the territory of the United States. You still have your trademark. Nobody's infringing your trademark here. They're doing what they're doing. But you never, all the investment that you say you made to develop the drug was done in Canada. It wasn't done here. It's not as if your generation of the investment or the economic development of the host state or the contribution of capital was made here with respect to the intellectual property. So that's an architectural problem which is quite fundamental when you consider IP claims in investment treaty protection. And it comes up in different forms, in different ways. So, and we've had 3 cases which all of you know. One is Philip Morris v. Uruguay. There were actually 2 Philip Morris cases, one against Australia, one against Uruguay. The Australian one was dismissed on jurisdiction for different reasons. The one on Uruguay was also didn't proceed beyond a certain point because there's a doctrine of police powers. And within investment treaty protection, if you are undertaking a particular measure under police powers, which is for public health and so on and so forth, then those things are uncompensable. They are not counted as expropriation. So that was considered as a police power thing. That's also somewhat similar to what the Philip Morris WTO decision was. Saying public health and nothing doing. And in any case, you see, the nature of the right in your in intellectual property, I'm saying your intellectual property, is exclusionary. Is not as if you get a right to do something. It's not as if you get a right to mine, which I take away. The right that you get is you exclude others from using negative rights. Right. TRIPS Article 16 and all that. So here, for a country to actually expropriate your right, it would have to do something really so high and so egregious that countries usually don't do. It would actually have to take your trademark and give it to someone else, like Russia, for example. Then McDonald's, now you use the M, somebody else. That might qualify as a expropriation under investment treaties. But let's assume I just stop that. For example, there was a very interesting case, Shell. There was this was Shell v. Nicaragua. Shell v. Nicaragua, or what was it?
Yeah, it was Nicaragua.
Right, exactly. So there was a
airport case.
No. There was a mass tort claim. They said Shell was selling banana pesticides, which caused great damage, and it was Nicaragua, which country else come. But they said you have to pay 500 million in damages. The court said here's a mass tort claim, 500 million in damages to be paid to the community at large. To which Nicaragua firstly went in appeal and said we won't pay. So the government said if you won't pay, we'll expropriate your trademark. We won't let you use a trademark here. So Shell said we are going to sue you, and they did under the Dutch-Nicaragua treaty. They said we'll sue you, we won't pay. Now that was an interesting thing. And Nicaragua had already taken the defense in that, which never actually came to pass in that decision. They said, well, we've not really given your trademark to somebody else. We've just taken it away in the sense that we've suspended it from the registry. We haven't given it to someone else. So it's not as if we've caused great damage to you. It still exists somewhere. You pay us, we held it on something, we held you at gunpoint. But they never really got to a decision because it was overturned in appeal in Nicaragua. So that is where it usually gets to. So you have Philip Morris, you have Eli Lilly, of course, as you mentioned, Canada. So that is a close one because that's the only one that deals with patents. All the other cases are dealt with trademarks so far. And there it had this requirement, the promise requirement.
Promise doctrine.
Promise doctrine.
But it's interesting that the Supreme Court of Canada
Ultimately, that is no good.
Yeah.
No good, the doctrine is gone.
Yeah.
But you see, even within investment treaties, um, in Eli Lilly, just to recap for everybody else, there was a promised doctrine of utility, which was a somewhat of a jurisprudential characteristic of Canada, somewhat like our 3D here in Novartis. It's our own characteristic.
British doctrine.
Yeah, okay, but nevertheless, nevertheless. And so this was challenged by Ila Lila saying this is something that's against fair and equitable treatment under the NAFTA. To which the tribunal said, no, there are certain things that is not for us to judge. And there is no such drastic change in the practice of this jurisprudence. It was already there when you applied for the patent. It was already out there and you applied with the risk of knowing that this is there in the regulation. So it's not for us to frame the regulation because the property right has to be granted by the territory. After that, we can protect it. But the granting of the property right has to occur in accordance with the laws of the territory. And that's not something that the investment treaty regulates. The creation of the property is territorial. Protection is there.
So it means that arbitration, even at that stage, investor state, is not so attractive as far as IP owners are concerned.
Now it depends on the text of the treaty, which is what I'm coming to. So there was the first generation treaties, then there was second generation, third generation. There's been a great backlash. So very obviously going forward, you might not have stronger language in the treaties, especially where India is concerned. And I can read out some of these new treaties that have nothing. But if you look at the US ones, and you know what hurts and what counts for them. So the new USMCA, no matter what Trump might be saying that we want to get out of the FTAs and all that, it is exactly the opposite in text. It has such protections that are hitherto unseen and unknown and are really strong. And the IP chapter that I was just looking at is 60 pages long. In the NAFTA, it was 20. In Indian BITs, it's one section with one line.
Clause.
One clause.
Whatever US can't get in multilateral treaties is now coming
It's
in.
now
And
back to bilaterals.
We'll come back here and it will become bilaterals. And certainly, I mean, this is what we were thinking of writing on, is with the tariff wars and with retaliation, potential IP retaliation that might hurt that Western hemisphere. This might come to be something that becomes more talked about. Having bilaterals, which is what the position was before TRIPS. Essentially, they were going out doing bilaterals, then they came into TRIPS.
I personally don't see a lot of future for IP in.
It doesn't exist anyway, even today, in treaty arbitration.
And I don't see a lot of future in it also.
In the bilaterals?
Yeah. Because I think, yes, there may be a few countries which will agree to very severe IP clauses in bilateral investment treaties, but I don't see many countries agreeing to it. No. Yeah. I mean, they may have their draft. India also has a draft BIT version, which no country in the world wants to sign. But I don't know.
Now the thing is when the obviously this is the idea. For example, the India-EFTA thing, they have an IP chapter. Assuming they go and they try and have an agreement with the US saying, please specify your tariffs, we'll have the agreement with the whatever US FTA. Surely there'll be an IP chapter. Surely they will propose the strongest potential IP chapter. In the USMCA, for example, they have biologics, they have software, they have testing data for chemicals and pharma and all those kinds of things. Surely it will be there on the draft. Now what happens
But
on
in
that
terms of arbitrability, I think there is still some weakness as far as IP claims are concerned.
No, arbitrability in investment treaty. No, that's something not at all. The problems of arbitrability that we talked about here, domestic, doesn't happen. No chance. Everything is arbitrary.
Everything
right
is
right down to the wire. Nothing is excluded in the arbitrable part. But yes, there are exceptions to it. Like you saw, police powers thing. There are limitations on
the exceptions are,
and there are also limitations to what the investment is. The investment, which is very foundational, and not too many people have written about it. Actually, nobody, frankly. But it's a common theme in those cases. Some of them have sidestepped that. But you have the very first question that comes up in any treaty dispute, in any award that you read is, where's the investment? And then who's the investor is the second one. But the investment has 4 components.
But Manu, when I said arbitrability, what I meant was that the exceptions that are out in terms of compulsory license or revocation, etc., they are far more broad in the sense that the country doesn't need to do anything in relation to IP. If you want to just depress the value, you grant a compulsory license or you revoke a patent, and if that is not subject to
but
arbitration.
the TRIPS is referred to in every place. So for
Yeah.
example,
Yeah.
I mean, so that standard is whatever that standard is.
Yeah.
Oh, so what would happen is in a situation like this, I mean, although there's a lot of, you will know this better than me certainly, there is a jurisprudential gap as far as indirect expropriation is concerned. In theory it exists, like in principle it exists, right? So in a situation where you completely dilute the value of my, assuming I cross the investment threshold, I completely dilute the value of the investment through say a compulsory license. But the issue is if you see the award in the Eli Lilly case also, there's a strong reference to margin of appreciation.
No
It is a
drastic
principle
changes.
of PIL, right? That especially when it comes to a quasi-judicial act or a judicial act, right? We are not sitting in appeal as an international tribunal. We are not sitting in appeal. There is a margin of appreciation given to the domestic courts or quasi-judicial bodies. So they also don't want to touch it unless it is so perverse
No, there are enough tribunals out there
that it shocks the conscience of the.
now this is where things become a little dicey. And since everybody is a friend here, an academic setting, you can orchestrate a tribunal that will give you exactly what you want in the way that you want it. And this test of margin of appreciation, non-drastic change, all that doesn't count for anything. Like I said, it's hierarchical. There's no stare decisis. They might even notice Eli Lilly, they might choose to ignore it altogether because that's the award. And even more perverse awards have been passed for billions and billions of dollars. So it might come to pass in that system. The possibility exists. Now,
This is why India wants to get out of the.
Yeah.
well, actually, they want to get out, but they can't get out.
What is
also.
the leverage?
Because the world is breaking apart. So when you're sitting across the US on the table and saying, well, what do you want? So this is the first chapter the US will have. And we'll have our own chapter on textiles or something. And that's how it will work. You know. So
And see, in all this, and we were discussing this the other day, there is not just a legal risk. There is a political risk and there is a investment reputation risk. What do you do with that? And how do you navigate? I mean, even if you navigate the legal risk.
Yeah, you want to be seen as investor friendly.
Absolutely, absolutely. So, I think with that good note, we can conclude. But unless somebody wants to add, to the discussions and some point that you think is important,
Yeah, only I
because
want to
there
know
is-
how long Manu studied for this.
this was, I came in the time that I spent reading it. That's the time I spent.
Yeah.
And you deduct what others didn't let you.
In my interruptions.
Well, thank you all so much. Ashutosh, your memento is waiting here, but we'll deliver it to your office, and you can see it once you're. When are you back?
I'm back on 8th.
Okay. So we'll see you then, and we'll just have a small memento for everyone. Thank you so much.
Take a leave. I have my class waiting up.
Sure. But they are here. So maybe you can have a cup of tea and then
Thank you.
Yep.
They will also have tea.
Thank you, everyone.
Yeah.
Thank you.
Start with. Thank you, Ashutosh.
Thank you.
Yeah.
Like one hand giving to the other hand.
I can keep passing out.
I think you can give that side. Go ahead. वहाँ पे भी लीजिए, यहाँ वहाँ पे ले लीजिए. Fast in the process.
Like the actual doctor.
Aditya, thank you so much.
यहाँ पे conference.
Correct.
My turn.
Thank you.
Anybody remaining? Hey, let's go to the auditorium for everybody here. We can go to the auditorium quickly for a snack.
Samosa rakhe na doctor?
Huh? Let's see what is there.
Delhi always has samosa.